Hey everybody, welcome back to the channel. I appreciate your time. Thank you for watching. Yesterday, I told you last night about the breaking news that the federal bump stock ban was struck down. And I did say I was still going to rip through the 62-page decision, and I've done that. And I want you to understand how well this decision was written. As many of you know, and some might not, the strength of a court's decision always comes down to how it was written. And if there are gaping holes, then that's where the anti-gunners, in the Second Amendment's case, that's where the anti-gunners attack. For instance, the sensitive spaces, sensitive places that New York has gone after, New Jersey and Delaware and California. They went after that because when it was brought up by Justice Kavanaugh in the Bruin decision, he wasn't very specific about it. And he left a little vagueness. So that's what they're attacking. Here, I don't see much vagueness on this bump stock ban destruction, and I want you to understand the way it's written and what it says, because I get a lot of questions about it, so I figured we'll go over it together. This is going to be a very analytical video, a little long. I'm going to show you a lot of the things from the decision. My hope is that you'll stick around with me because A, this is important information. B, it's good to know how courts work, especially when they're deciding on what we determine is an infringement and we want it challenged. This is the process it goes through. So here is page 1, and the case is Cargill versus Garland. Now, Cargill is challenging that the ATF violated the Administrative Procedure Act. And the Administrative Procedure Act, real quick, is just the process in which federal agencies develop and issue regulations. That's all. And here's how the decision starts out. It says, since the National Firearms Act of 1934, federal law has heavily regulated machine guns. Indeed, as proposed, that law was known to many as the Anti-Machine Gun Bill. The possession or transfer of a machine gun was eventually banned through the Gun Control Act of 1968 and the Firearms Owners Protection Act of 1986. Today, possession of a machine gun is a federal crime carrying a penalty of up to 10 years incarceration. This appeal concerns a regulation promulgated by the Federal Bureau of Alcohol, Tobacco, Firearms, and Explosives, purporting to interpret the federal prohibition on machine guns as extending to bump stocks. A bump stock is a firearm attachment that allows a shooter to harness the natural recoil of a semi-automatic weapon to quickly re-engage the trigger after firing, enabling him to shoot at an increased rate of speed. When ATF first considered the type of bump stocks at issue here, it understood that they were not machine guns. ATF maintained this position for over a decade, issuing many interpretation letters to that effect to members of the public. But ATF reversed its long-standing position in 2018, subjecting anyone who possessed a bump stock to criminal liability. ATF reversed its position to a great extent in response to the tragic events that occurred in Las Vegas on October 1st of 2017. On that day, a deranged gunman murdered dozens of innocent men and women and injured hundreds more. To carry out this appalling crime, the gunman used many weapons and utilized many accessories, including bump stocks. Public pressure to ban bump stocks was tremendous. Multiple bills to that effect were introduced in both houses in Congress. But before they could be considered in earnest, ATF published the regulation at issue here, short-circuiting the legislative process. Appellant Michael Cargill surrendered several bump stocks to the government following publication of the regulation at issue. He now challenges the legality of that regulation, arguing that bump stocks do not fall within the definition of machine gun as set forth in federal law, and thus that ATF lacked the authority to issue a regulation purporting to define the term as such. Cargill is correct. A plain reading of the statutory language paired with close consideration of the mechanics of a semi-automatic firearm reveals that a bump stock is excluded from the technical definition of machine gun set forth in the Gun Control Act and National Firearms Act. But even if that conclusion were incorrect, the rule of lenity would still require us to interpret the statute against imposing criminal liability. A rich legal tradition supports the well-known rule that penal laws are to be construed strictly. The definition of machine gun as set forth in the National Firearms Act and Gun Control Act does not apply to bump stocks. And if there were any doubt as to this conclusion, we conclude that the statutory definition is ambiguous at the very least. The rule of lenity therefore compels us to construe the statute in Cargill's favor. Either way, we must reverse. That's big, guys and gals. That's really, really big. What they're saying is that the ATF for decades said it's not a machine gun. And all of a sudden, when they got some pressure from President Donald J. Trump, because he didn't like bump stocks, remember, and he didn't like suppressors, well, he was able to put enough pressure on the DOJ where they said, all right, ATF, do a rule, let's make it go away. Similar to what they're doing with 80% lowers, similar to what they're doing with pistol braces, similar to what they tried to do with green tip ammunition. You see a pattern here? Well, the way that this is worded, guys and gals, could stop the pistol brace rule from coming out and destroy the frame and receiver rule. So this decision could be huge. So we're gonna have to watch going forward whether the government decides to appeal it or not, but then that would put the Supreme Court in play. I don't know. Does the Attorney General push that envelope that far? I don't know. So the next part of the decision, they talk about what actually is a machine gun and disconnectors and all that stuff. And then there's this. The statutory definition of a machine gun also includes devices that convert an ordinary firearm into a machine gun. See US v. Camp, holding that a switch, which, if flipped, could cause semi-automatic rifle to fire continuously, as a device that turns an ordinary firearm into a machine gun. The issue presented here is whether a bump stock is such a device. A bump stock is an accessory that attaches to a semi-automatic weapon and assists the shooter to engage in bump firing. Bump firing, in turn, is a technique whereby a shooter uses a firearm's natural recoil to quickly re-engage the trigger, resulting in an increased rate of fire. It is possible to bump fire an ordinary semi-automatic rifle without any assisting device, but a bump stock makes the technique easier. So the court acknowledges, yeah, you can use a bump stock, but you can also use your finger or other ways. There are many ways to bump fire a rifle or a gun, and that comes into play here, and it actually, further down in this decision, destroys the government's stance, and it was really, really cool to read this. But from the time ATF first considered non-mechanical bump stocks to 2017, it categorized that type of bump stock as not being a machine gun. In that time, the Firearms Technology Branch issued dozens of classification letters regarding non-mechanical bump stocks, each time arriving at the same conclusion. And then they put in that letter here in the decision. Now remember, they said that there were bills in both chambers in Congress looking to do something with bump stocks, but then Trump's ATF took the lead and reissued the rule, and that's where the process ended. Well, the court goes back to that by saying even Dianne Feinstein, Mr. and Mrs. America, turned them all in. She had a problem and was concerned with what happened with ATF taking the reins. Senator Dianne Feinstein, who sponsored one of the bills mentioned above, expressed concern with the proposed rule. She said, until today, the ATF has consistently stated that bump stocks could not be banned through regulation because they do not fall under the legal definition of a machine gun. Now, the department has done an about-face claiming that bump stocks do fall under the legal definition of a machine gun, and it can ban them through regulations. The fact that ATF said, as recently as April of 2017, that it lacks this authority gives the gun lobby and its allies even more reason to file a lawsuit to block the regulations. Unbelievably, the regulation hinges on a dubious analysis claiming that bumping the trigger is not the same as pulling it. The gun lobby and manufacturers will have a field day with this reasoning. What's more, the regulation does not ban all devices that accelerate a semi-automatic weapon's rate of fire to that of a machine gun. Both Justice Department and ATF lawyers know that legislation is the only way to ban bump stocks. The law has not changed since 1986, and it must be amended to cover bump stocks and other dangerous devices like trigger cranks. Our bill does this. The regulation does not. Now, some of you may remember that there were many bump stock cases, and all of them had failed other than this one, and this court brings that up as well. 3 of our sister circuits have reviewed preliminary injunction motions relating to the final rule. The issues engendered great disagreement, but each circuit that has addressed them agrees that the definition of machine gun within the National Firearms Act and the Gun Control Act does not unambiguously mean what the government says it means. Each circuit ultimately denied preliminary injunctive relief, and the Supreme Court denied each of the certiorari petitions. A divided D.C. Circuit panel determined that the final rule is ambiguous, but applied Chevron deference to the government's statutory interpretation. The dissent contended that the final rule contradicts the statute's plain meaning. Although the Supreme Court denied certiorari, one justice wrote separately to explain his view that Chevron does not apply because the government has expressly waived its application. 2, it does not apply to regulations bearing criminal sanctions. And 3, the final rule directly contradicts the government's previous interpretation. In another divided opinion, the 10th Circuit reached the same conclusion as the DC Circuit, that the final rule was ambiguous and entitled to Chevron deference. The court initially granted rehearing en banc, vacating the panel decision, but later vacated the order as improvidently granted, reinstating the former opinion. 3 dissents were written, each of which was joined by 5 of the 11 participating judges. The first dissent would have held that 1, the statute unambiguously does not apply to bump stocks. 2, Chevron does not apply either because the government waived it or because it does not apply in criminal context. And 3, the final rule may violate non-delegation principles. Finally, in yet another divided opinion, the 6th Circuit panel ruled against the government, declining to apply Chevron deference and holding the statutory definition of machine gun does not include bump stocks, and that's the Gun Owners of America case. In addition to these circuit decisions, the Navy Marine Corps Court of Criminal Appeals considered the final rule in the context of a criminal prosecution for possession of a machine gun. That court determined that under the best reading of the statutory language, a bump stock is not a machine gun. But it ultimately found that the statute is ambiguous and applied the rule of lenity to construe the statute against imposing criminal liability. It dismissed the charge for possession of a machine gun. But here, the government has declined to invoke Chevron in any of the lawsuits challenging the final rule. Nonetheless, several circuits have applied Chevron deference to challenges of the final rule, and so we will consider Chevron's applicability below. But before we do, we determine the statute's meaning using traditional statutory interpretation tools. That is, the old-fashioned way. Now then they go right down to grammar and what grammar means and how a single function of the trigger is not the single pull of a trigger and how the ATF tried to change that up. A function of the trigger is mechanical, where a pull is a physical thing from a person, from a human, and they're not the same, so it doesn't work in ATF's favor that way either. And then there's this part. The government says that this straightforward interpretation defies common sense. So by literally holding the definition to what it says is not using common sense according to the government. The world we live in today. And then the court said this. We reiterate that a shooter can bump fire an ordinary semi-automatic rifle even without a bump stock, but nobody, not even the government, contends that semi-automatic rifles are machine guns. That concession damns the government's position. As Cargill recognizes, if ordinary bump firing constituted automatic fire, the final rule would convert a semi-automatic weapon into a machine gun simply by how a marksman used the weapon. That absurd result reveals the flaw in the government's line of reasoning. In addition to implying absurd results, the government's position is quite telling. It would allow the use of semi-automatic rifles, which can bump fire, but prohibit the use of non-mechanical bump stocks even though there is no mechanical difference between the two forms of gunfire. Rather, the meaningful difference is that with a non-mechanical bump stock, bump firing is easier and can occur at a faster rate. That is the distinction Congress certainly could have addressed in the National Firearms Act and Gun Control Act, but Congress did not prohibit machine guns according to how quickly they fire. It prohibited machine guns according to the way that they fire. And semi-automatic weapons do not fire automatically, even when equipped with a non-mechanical bump stock. They then talk about Chevron and how it does not apply, obviously because of the criminality at stake. And then, in closing, they say this. Having determined that the judgment of the district court must be reversed, we remand this case to the district court to enter judgment for Cargill and to determine the proper scope for relief. It is well established that the plaintiff's remedy must be tailored to the redress of the plaintiff's particular injury. And as an initial matter, vacatur of an agency action is the default rule in this circuit. Vacatur is the only statutorily prescribed remedy for a successful Administrative Procedure Act challenge to a regulation. But the parties have not briefed the remedial scope question, and it may be the case that a more limited remedy is appropriate in these circumstances. We express no opinion on that question other than to observe that the district court is well placed to answer the question in the first instance. We therefore remand this case to the district court with the instruction that it enter judgment for Cargill and determine what remedy, injunctive, declarative, or otherwise, is appropriate to effectuate the judgment. So, this decision was very precisely worded. When I read it, I'm not an attorney, but I was in courts, in and around courts for 24 years. This is well written. Now, some of my attorney friends might be able to poke holes in it because that's what attorneys do. But I don't know if this is something that they want to kick up. The government want to kick it up to the Supreme Court. They might just let it lie. That's why I always let Anthony over at the Armed Scholar take the lead on this stuff, because I come at it from a different side than he does, and often when we both get together, magic happens. But this is a great decision. The federal Bumpstock rule, the ban, it was a ban, promulgated by a rule, and a written rule that created criminal penalties, thus being treated like a law. And ATF can't make law because they're unelected bureaucrats. So it was great. They addressed everything. They addressed the definition in Congress. They addressed that any rifle, any semi-automatic rifle can be bump fired, yet they're not machine guns. Phenomenal. If you live in this circuit and you have either turned in bump stocks, destroyed bump stocks, or had them taken by law enforcement, you might now have a decision that you can point to directly and immediately in court and get some assistance. I don't know. Again, I would refer you to an attorney. But this is good news, guys and gals. If you are into this, how the court operates, let me know, and maybe I'll continue breaking down decisions. And until we see each other again, be safe, stay vigilant, carry a gun to keep you, your friends, your family, your community safe. Hit that subscribe button down below. YouTube's playing. Yesterday was wacky. They stopped processing some of my videos. I don't know why. Maybe it's a glitch. I don't know. I got a bunch of stuff that was demonetized yesterday. I'm hoping it's a glitch. Either way, they didn't want this information to get out yesterday. They tried. And check your subscription. Check it because they're playing that game. I will see you on the next one, guys and gals. Be safe, stay vigilant, carry a gun, keep you, your friends, your family, your community safe. I think I said it already, but it's true. And it's not going anywhere. Take care, y'all.